during a pretrial deposition in a medical malpractice case, my opponent, who I can't stand, asked my client to question, and now I object. And I refuse to allow my client to answer this question. The opposing attorney says my client has to answer this question. Who's right? Who's wrong? And what happens next? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, my client brought a lawsuit against her doctor claiming that he was careless, causing her significant harm and injury. And we have a qualified medical expert who supports our claim that there is a good valid basis to bring this case and that the doctor was in fact careless and did violate the standard of care, causing this patient significant injury. Okay, during the course of this lawsuit, the defense attorney has an opportunity to question my client. It's known as a deposition. Lawyers also call it an examination before trial. And this happens in our office. There's no judge there, there's no jury there, but there is a court stenographer there to record all of the questions my client has asked and all of my client's answers. Okay, so now during the course of questioning, this opposing attorney who I've dealt with before, and who, by the way, I can't stand because they are a big pain in the butt, okay, we've butted heads many times before, but I still have to be professional. I still have to go ahead and respect the fact that she is on the opposing side representing her clients to the best of her ability. And now she asks my client a question that I think is totally inappropriate. And now I turn around and say, objection! Don't answer that question. And now the defense attorney starts arguing with me. Your client has to answer that question. I'm not going to change my question. There's nothing wrong with my question. That's a perfectly appropriate question. We are arguing about whether or not this question is appropriate for this type of case. And we are now getting into a vicious argument about whether or not my client has to answer this question. The defense attorney would love nothing more than to get an answer to that question. I, on the other hand, would prefer not to have my client answer that question. Now, the key issue underlying all this is the question that she is asking, is it a legally appropriate question? Or, on the other hand, is it a totally off-the-wall, bizarre question having nothing whatsoever to do with the claims in this case, or with the defenses in this case, or whether it's something that might lead to evidence that she could use at the time of trial? Well, we're in a stalemate, right? Now, I'm not allowing my client to answer the question. She wants an answer to the question. What happens next? In the old days, one or more of the attorneys would go ahead and get on the phone to the court, see if he was available, and if he was available and willing to talk to us, now he would hear the arguments from both sides and then make a snap judgment right there on the phone to go ahead and tell us either yes, have the client answer the question, or no, it's not appropriate, the client does not have to answer the question. Well, nowadays, that type of request rarely happens. Why? Because judges have gotten fed up with being interrupted during the middle of their day about something that he knows nothing about and have to make a snap decision without knowing the details or maybe even the law on this particular issue. In that instance, the judge is again at a significant disadvantage, and he might make the correct decision, he might not. And now the attorneys have to live with that decision or try and appeal it later on. So most judges nowadays typically will not allow the attorneys to pick up the phone and call the chambers to request that the judge intervene. What happens then? What happens then is that one of the attorneys now will basically say to the court reporter, okay, mark that for a ruling. We're going to readdress this after this deposition is finished. Now what does that mean? It means that because there's a stalemate and now neither side is willing to proceed forward on that particular issue, let's go ahead and continue with this deposition, ask all the other remaining questions that need to be asked, and now, after this deposition is finished, and after we have obtained the transcript of what has been testified about, now the attorney who wants this question answered can go into court and formally ask the judge for some type of response because we have refused to allow the client to answer the question. That's usually what will happen. So now we will continue forward with the rest of the deposition. Now that has been put to the side and preserved, and later on, if they feel it's so necessary and so important, they can always ask the court to intervene in a formal sense by making a motion, a written request to the judge to take action and do something. Hey, judge, we want you to bring Oginski's client back because he did not allow us to ask the question that we wanted to ask. And because you're now making us go through this all over again and inconveniencing us, we want you to punish Oginski for his failure to allow his client to do these things. And now the judge has to consider whether or not it was appropriate for me to tell my client not to answer the question. Here's something else you should know that you may not know. There are really only 2 or 3 instances in a medical malpractice case where I am legally permitted to tell my client not to answer the question. In practically every other instance, the witness has to answer the question, even though it may not be related to the issues in this case, even though it may not be related to the damages in this case, or maybe even the defenses in this case. That's known as the discovery phase. And because it's discovery, the attorneys are permitted pretty much wide latitude to ask lots of questions, even though that information may not even be able to be used at the time of trial. So why do I share this quick information with you? I share it with you just to give you a quick sense of what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.